This program is brought to you by Emory University.
It is my privilege to introduce the first panel in today's symposium, and that is entitled, "In a Class by Itself, Has the Roberts Court Slammed the Courthouse Door on Class Actions?" Today, the panel is being moderated by Professor Jonathan Nash of our own Emory Law School. Professor Nash specializes in federal courts, the study of courts and judges, and environmental law. Before coming to Emory Law, Professor Nash served as Robert C. Cudd Professor of Environmental Law at Tulane University. He teaches courses in federal courts, habeas corpus, legislation and regulation, land use, and environmental law. Before his arrival at Emory, Professor Nash was a visiting professor at the University of Chicago Law School. Professor Nash is a prolific scholar, publishing in many top-ranked law journals. Prior to teaching, Professor Nash was a law clerk to the Honorable Donald Stewart Russell of the United States Court of Appeals for the Fourth Circuit and to the Honorable Nina Gershon, then Chief Magistrate Judge of the U.S. District Court for the Southern District of New York. Professor Nash also practiced as an attorney in New York. He received his LLM from Harvard Law School, his JD from New York University School of Law, graduating magna cum laude, and his bachelor's degree in mathematics summa cum laude from Columbia University in New York. Professor Nash.
Well, thank you very much, and thanks to all of you for coming, and thanks to our panelists in advance for what I'm sure is going to be a fantastic panel discussion. Our topic this morning is in a class by itself, has the Roberts Court slammed the courthouse door on class actions, which I think follows up very naturally on Professor Miller's remarks earlier. We do indeed have a most distinguished and expert panel on this topic. So what I would like to do is introduce everybody in the order in which they're going to be speaking, which is from my far left and back. And then I will kind of get out of the way and let everybody at it. I'll do some introductions. In the interest of time, I commend you to the program for full introductions, but just to give you a sense of who we have here, again, an excellent panel. Mary Kay Kane is the Chancellor and Dean Emeritus of the John F. and the John F. DeGardy Distinguished Professor of Law Emeritus at the University of Hastings College of Law in San Francisco. She is a graduate of the University of Michigan, having earned both her bachelor's degree and law degree from that institution. Dean Kane has written numerous articles and books in her major field, including a Hornbook on Civil Procedure, Hornbook on Federal Courts, and numerous volumes of the co-authored Wright and Miller Federal Practice and Procedure treatise. Dean Kane also served as a member of the Standing Committee on Practice and Procedure of the U.S. Judicial Conference from 2001 through 2007. Richard Marcus holds the Coyle Chair in Litigation at the University of California Hastings College of Law in San Francisco. Since 1996, he has served as Associate Reporter of the U.S. Judicial Conference's Advisory Committee on Civil Rules. He was one of the primary drafters of the 2003 amendments to Rule 23 on class actions and serves as reporter to the Advisory Committee's Rule 23 subcommittee. He is the author of leading casebooks on complex litigation and civil procedure, and as well as 4 volumes of the Wright and Miller Federal Practice and Procedure treatise. Martin Redish is the Lewis and Harriet Ansel Professor of Law and Public Policy at Northwestern University School of Law, and he teaches and writes on the subjects of federal jurisdiction, civil procedure, freedom of expression, and constitutional law. In addition to that, he is senior counsel to the law firm of Sidley and Austin. Professor Redish received his bachelor's degree with highest honors in political science from the University of Pennsylvania and his JD magna cum laude from Harvard Law School. Professor Redish has published numerous books and articles, and there's a study from 2009 where he was identified as the 16th most cited legal scholar of all time. Professor Redish has appeared as an expert witness before numerous congressional committees and most recently testified before the House Judiciary Committee on the need for class action reform. Theane Evangelis is an appellate and general commercial litigator with a focus on class actions in the Los Angeles office of Gibson, Dunn, and Crutcher. She represents clients in state and federal courts at every level across the country and is active in shaping the law governing class actions. She represented Walmart in the Walmart versus Dukes case, successfully persuading the Supreme Court to reverse certification of the largest employment class action in American history, and won a unanimous decision from the Supreme Court expanding federal jurisdiction under the Class Action Fairness Act in Standard Fire versus Knowles. Theane also represented the plaintiffs from trial through the U.S. Supreme Court in the successful federal constitutional challenge to California's ban on same-sex marriage, Proposition 8, in the Hollingsworth case. After law school, she served as law clerk first to Chief Judge Kaczynski on the Ninth Circuit Court of Appeals and then to Justice Sandra Day O'Connor on the Supreme Court. So without further ado,
Thank you. On this panel, we were asked to opine on the class certification fallout from the court's decisions in Walmart and Comcast. And I think while Professor Nash is right that it flows naturally from Arthur Miller's earlier remarks, at the same time, not surprisingly, if you've ever been around or worked with Arthur Miller, he has somewhat stolen our thunder, if you will. But we will try to offer a few additional things along the way. So in thinking about this assignment, it struck me that such an exercise effectively entails what psychologists who deal with disaster counseling might refer to as understanding the 3 stages of the grieving process. So my remarks this morning will attempt to lead us along that process. Stage 1, shock and concern upon reading the opinions. Consider first Walmart, which involved 2 pivotal class certification issues. The first was the court's unanimous decision that the action, which sought injunctive relief, back pay, and damages on behalf of a nationwide class of women alleging sex discrimination in employment, could not be certified under Rule 23b-2 as an action seeking predominantly injunctive relief. The lower courts had been grappling with these types of hybrid suits for decades. And although they had developed different standards for evaluating whether damages relief was incidental to the injunctive relief, all had ruled that Rule 23b-2 class certification was possible under certain circumstances. Further, they typically held that back pay claims met their defined standards. The Walmart court rejected all of this lower court precedent, holding that back pay claims could be certified only if the court determined that they met the predominance and superiority requirements of Rule 23b-3. So taken at face value, this holding appears to eradicate the possibility of hybrid class certification, requiring plaintiffs to meet the more difficult predominance standard of Rule 23b-3. And it injects that standard into an area of class litigation that had not been in a great state of flux prior to this decision. The second Walmart holding, which was 5-4, elaborated a new higher threshold for satisfying the Rule 23a-2 common question requirement. The court's new standard creates a complicated threshold analysis for a prerequisite on which most lower courts had not placed much emphasis at all. Now, the plaintiffs must show their claims depend upon a common contention, and that contention must be, to quote from the opinion, capable of class-wide resolution, which means that determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke. Further, to resolve that question, the lower courts were instructed to engage in a rigorous analysis that might require some overlap with the merits of the plaintiff's underlying claim, raising important questions about what proof might possibly meet that standard. As noted by Justice Ginsburg, writing for the dissent, the majority appears to disqualify the class at the starting gate. More reasons for concern emerge when we turn to Comcast, another 5-4 decision, this time in antitrust. It addressed the Rule 23b-3 predominance of common question requirement. There, the majority ruled that the lower court erred by refusing, on the ground that it required an inquiry into the merits, to probe whether plaintiff's damages model could support determining damages on a common basis for purposes of deciding whether Rule 23b-3 was satisfied. The need to inquire into how the merits would be proved in order to satisfy the predominance requirement was well established prior to this decision. However, it generally had been held in antitrust, as well as in other litigation, that certification was appropriate under Rule 23b-3 even when damages might present individual issues. Even more striking is the fact, noted by the dissent, that in Comcast itself, the parties had not challenged the district court's decision to require common proof of damages, so the question of the propriety of that inquiry was not litigated below. So let's move to stage 2, examining the fallout. Before prospective class action plaintiffs and their attorneys exhibit suicidal tendencies, I would urge that we examine how the lower courts have reacted. Several months after Walmart, I delivered a lecture reviewing the court's most recent class action rulings, including Walmart. And I found that in the immediate 6-month period following that decision, an admittedly short period of time, the lower courts were not closing the door on class actions. Although certainly there were courts that applied the Walmart criteria rigidly and denied certification either under Rule 23b-2 or under Rule 23a-2, others found distinctions between their cases and Walmart. Indeed, the ability of lower courts to distinguish Walmart from the litigation before them so as to make positive commonality rulings appeared in suits involving wage and hour disputes, breach of form contracts, deceptive trade or advertising practices, insurance coverage, securities and antitrust class actions, prisoner civil rights cases, Fair Housing Act litigation, and other constitutional litigation. That's just in 6 months. If we look to cases in this last year, when courts and litigants have had more time to digest the Walmart opinion and decide how to apply it, the trend appears to be the same. This is not to suggest that Walmart is being ignored or has not had an impact. Certainly, some courts have appeared to embrace its stricter standard. But my own view of the current state of affairs is that Walmart has not slammed the door. Generally, its biggest impact, not surprisingly, appears in the employment discrimination area, particularly when discrimination is alleged to be reflected in subjective decision-making. Indeed, on remand in the Walmart case itself, District Judge Charles Breyer rejected a certification motion for an amended statewide class action. He found that while plaintiffs had scaled down their class to some 150,000 class members from over 1.5 million, just in the state of California, it presented the exact same problems that foreclosed certification of a nationwide class action. Thus, the Supreme Court's decision certainly has given ammunition for those litigants who would prefer stricter standards, while yet other courts appear able to distinguish their circumstances from it. In the limited time that Comcast has held sway, a similar lack of a clear trend against class certification exists. Courts so disposed appear able to limit that case to the antitrust context in which it arose and to its peculiar facts by which damages appeared to be intertwined with the liability issues. Indeed, in 2 cases remanded to the appellate courts by the Supreme Court to be reconsidered in light of Comcast, both the 6th and the 7th Circuits reaffirmed class certification under Rule 23b-3, finding that, unlike Comcast, their cases did not require damages to be considered in order to determine whether Rule 23b-3 was satisfied. The 7th Circuit, which you already heard, the Butler case, Professor Miller invoke, in the opinion by Judge Posner, even went so far as to state the following: it would drive a stake through the heart of the class action device in cases in which damages were sought rather than an injunction or a declaratory judgment to require that every member of the class have identical damages. If the issues of liability are genuinely common issues, and the damages of individual class members can be readily determined in individual hearings, in settlement negotiations, or by creation of subclasses, the fact that damages are not identical across all class members should not preclude class certification. In sum, short-term experience indicates that it would be premature to suggest that the modern class action has seen its demise as a result of these 2 decisions. So that means we should move to stage 3, which is gaining perspective. The conclusion I just stated, I believe, is buttressed by history. It is useful when evaluating recent events to think of what has occurred as a result of other major class action pronouncements and changes. Recall, if you will, the various restrictions that have occurred since the 1966 rule amendments created the modern class action. First, in the late 1960s and mid-70s, the Supreme Court decided Snyder versus Harris and Zahn versus International Paper, preventing the aggregation of class members' claims to satisfy diversity jurisdiction. Now, this limitation is eased by the enactment of the Supplemental Jurisdiction Statute and the Supreme Court's endorsement of its application to class actions. Second, in the mid-1970s, Eisen and its progeny required individualized notice to all identifiable class members in a Rule 23b3 damages class action, and also required plaintiffs to absorb the cost of that notice. Today, those burdens are lessened because technologies and other communications devices allow economies of scale for effective notice in modern actions. Third, in the late 1990s, as you already heard about this morning, as part of the asbestos litigation, we saw restrictions on class certification in limited fund class actions, additional requirements and concerns regarding the approval of settlement classes, and barriers to the settlement of future claims. A panel this afternoon will discuss the current state of affairs involving such settlements, but I would note here that it is more than a decade after these Supreme Court pronouncements, so clearly they did not end the possibility of such approaches, or the panel would have nothing to say to us today. And fourth, we must remember the 1995 and 1998 Securities Reform Acts, which created heightened and stricter certification criteria for securities class actions. At the time, these were forecast by plaintiff securities class action lawyers as wiping out their practice. Yet securities class actions continue to flourish today, as evidenced by the fact that in the last 2 years, the Supreme Court has had the occasion to rule on questions of how such claims can be proved on a class basis, and in both cases, the same court that gave us Walmart and Comcast upheld earlier precedent, allowing some common treatment for proof of reliance, and it refused to require proof of the materiality of defendants' misrepresentations or omissions to show predominance under Rule 23b3. So what looking at current developments from this broader perspective, as well as considering the current disarray in the lower courts, says to me, is that those predicting the death of the damages class action are still in phase 1 of grieving. It is true, the class action and what will need to be proved for certification is in a state of change, and change that imposes new burdens on those seeking to use this procedural device. But, as Professor Miller described, not today, but in his seminal article in 1979, entitled "Of Frankenstein Monsters and Shining Knights," I would suggest to you that these changes reflect the ebb and flow of the demands and types of litigation that have emerged. In short, I see us as going through another series of adjustments, not as participating in a burial ceremony. And the task now is to figure out how to operate in this new regime. So let me conclude by noting that I do not really want to be characterized as an undue optimist. Rather, I see myself as a pragmatist, whether as a result of witnessing the effect of past milestones in the class action field, or perhaps as a result of my 13 years as dean, which made me realize that to survive, you must roll with the punches. Whatever the reason, because I'm an academic and not a class action practitioner, and because I am constantly reminded of the enormous creativity and talent in the profession, I actually look forward to watching how the lower courts and class action litigants on both sides of the aisle adapt and shape this most important litigation device in the future. For I have no doubt that future class action litigation lies ahead. And to specifically answer the question posed by this symposium's editors, the Supreme Court has not slammed the door on class action litigation. It has merely changed the locks. Thank you.
I have the great pleasure of being sandwiched here today between my former dean and my co-author. So I'm going to be kind of a transition of sorts. I am delighted to be here. I want to thank the members of the Law Review who put this together so expertly. Even United Airlines was unable entirely to disrupt their perfect planning. I fear, as I said to Arthur after his presentation, that the rest of us, as always, as it's always going to be, are mere footnotes to his presentation or a pale shadow. I guess in light of what he had to say on another level, I could be characterized as a barbarian at the gates because I'm a percipient witness to more recent attention to Rule 23 than what he described, and there may be concern among some that the barbarians doing that might dismantle something in a harmful way. We all, or at least up until this point, I think Marty may go off in another direction, we all sort of ended up pointing in a similar direction, and that explains the title I made up for what I wanted to say, which is Bending with the Breeze. That's what lawyers and judges do, and I will try to elaborate on that going through 3 different steps. One, a little bit of discussion of the breeze, that is, these recent decisions. Mary Kay has addressed them quite thoroughly. 2, talking about something Arthur mentioned, which is what you might call other games lawyers play, other things lawyers and judges can do that produce results like results that come from formal class actions. And 3rd, given my barbarian or potential barbarian status, a little bit of what I will call, I think, mea non culpa, that is, not our fault, recognizing that most of what's happened in the last 50 years since the Big Bang in 1966 is due to what judges and lawyers have created, not to what the rules say. They've said about the same thing most of that time. So let me then start with my first topic, which is the impact of recent Supreme Court decisions. Surely the breeze is blowing largely in what you might call a pro-defendant or anti-class certification direction. That has caused, as the title of this panel suggests, concern that the game is over, the class action is dead, and so on. Measuring that possibility is a difficult challenge. One way of looking at it is to do what I do, although you probably don't want to, which is to read every issue of the Federal Rules decisions advance sheets when they arrive, cover to cover. Or maybe you'd rather have my report on what one finds on doing that. What I find on doing that is that they're hugely different now from what they were 10 or 15 years ago. 10 or 15 years ago, class actions very rarely appeared there. Now, seemingly, 1/3 of the pages in an average issue are about class certification. Admittedly, those decisions are longer than other decisions, like discovery decisions, but still, this is a big difference. In California, Mary Kay and I come from California. Some people regard it as a separate nation. At least in one regard, that's a reasonable view to take. That is the class action regard. And in that regard, after the Class Action Fairness Act was adopted, which Professor Miller mentioned, there had been a lot of noise about how state court class actions would disappear. We did a study of the California state courts and showed that was not happening. More recently, since I kept my eyes open to things people were saying in the field, just a few weeks ago on January 8th, the Bloomberg class action reports reported that employment discrimination class actions were, quote, white hot, unquote. So why is there so much commotion? Well, I'm going to return to this at the end since we are to conclude fairly rapidly so there can be discussion later. I'm going to return to this at the end, but it's a strange inversion of things that goes on when such developments happen. It seems that those who cry wolf shout that everything is terrible, and those who are gloating like the wolf with a smile on its face say, oh no, things haven't changed that much. Target, as you may, to illustrate that things may not have changed so much, Target, as you may recall, Target stores had a problem with data security. The Wall Street Journal on January 3rd had a story about that with the headline, quote, "Class action lawyers hope Target is a bullseye." So I think the hoopla is somewhat overstatement. The looming issues have already been mentioned. There's a panel this afternoon about arbitration. That's surely a looming issue. It seems to me Professor Gillies is going to be on that panel. It's been some time since she predicted that class actions would end. They haven't yet. I'm not endorsing or enthused about those decisions of the Supreme Court, but still somehow plaintiffs' lawyers reboot and things go forward. Halliburton, the case involving the fraud on the market theory, is a sword of Damocles, perhaps over securities class actions. Lawyers are resourceful. American lawyers are astonishingly resourceful, and so are American judges. So I don't think that's going to happen. Indeed, the worm may be turning on what people want in terms of kind of generalized expectations. For example, there was some mention of the attention to the merits at the class certification stage. Many plaintiffs' lawyers are quite unhappy about that. It certainly is understandable that they are. On the other hand, maybe the defense bar is beginning to take a second look at that idea. There was a defense appeal to the Seventh Circuit recently in which it was the defendants that resisted attention to the merits because they didn't want to have to respond to discovery. One of the things until this development that defense lawyers were often able to do is to persuade the judge to limit discovery to, quote, class issues, unquote, and not, quote, merits issues, unquote. And now if they're the same thing, that doesn't seem to work. Looking to the Halliburton fraud on the market possibilities, Mary Kay's former research assistant was on a panel in the California Lawyer in December concerning that possibility about securities class actions, his specialty. And he said, well, you know, if the Supreme Court does that, the Congress may get its act together and increase funding for the SEC, and we might all be unhappy, not happy about that development. So be very careful what you wish for is one lesson people need to keep in mind. Second point, and I've got to wind along towards my conclusion, as Arthur Miller mentioned earlier, Rule 23 class certification is not the only game in town. Let me talk about some other games, if you think of town, as we now do in our interconnected world, in a broader sense. First, there still are state courts. I've mentioned California. In mid-December, the legal press in San Francisco had a story entitled, quote, "Wage and Hour Class Actions Are Alive and Well in California." And so it goes. Maybe other states, maybe Georgia is not the same. Second, more than 10 years ago, it began to be said in the legal press that Canada is the new wonderful home for class action litigators from the U.S. In December, the Canadian Supreme Court issued a decision on openness to flexible class certification. So right next door, there's another place to go. Worldwide, the move is toward group litigation, not away from it. True, it's toward group litigation with the attitude that we want to avoid the drawbacks of the American class action. But the main point is that it is toward group litigation. There was a story in the New York Times within the last 6 weeks about Brazilian class actions against banks there involving claims totaling, as I noted down, $65 billion. So Rule 23 is not the only arrow in even American quivers. The judicial panel was mentioned. I think Arthur said that filings were down. Well, Judge Hayburn and Francis McGovern and Duke wrote an article a couple of years ago reporting that as of that time, of all civil actions in the federal courts, 15% were the subjects of judicial panel orders. So that's still a big deal. Third, since I better be moving on towards my conclusion, this is where I get to responsibility evasion, mea non culpa. Let's think about what's happened since the Big Bang. The Big Bang is what Arthur talked about, that he worked on with Ben Kaplan. That was followed by a Big Bang in filings with which Arthur wrote about so effectively in 1979, as Mary Kay mentioned. That was followed 10 years later or so by the report that the class action was dead. The New York Times ran a story quoting Arthur's successor as reporter to the advisory committee, saying class actions had their time in the sun and they're gone. Well, 10 years on after that, the chair of the advisory committee went before Congress and reported, gee, everybody's touched by class actions. They have not disappeared. Rules haven't had much of a role to play in that since the Big Bang. In 1996, there were proposed changes to Rule 23b-3, which Arthur mentioned. They were withdrawn after a great deal of aggressive commentary. The only thing that went in then was Rule 23F, allowing immediate review of class certifications decisions at the discretion of the appellate courts. And so the bad new thing, if anything, that happened was that the appellate courts actually got to review district court decisions. Now, maybe that's a bad thing if you don't like appellate courts. Some district judges don't. But that's not a big thing. I was a percipient witness in the 2003 amendments to the rules, and just as a segue to Marty Redish, I'll say they did things that might be suited to the environment he, I believe, will be describing to you. For example, we added Rule 23G, which among other things, that's on appointment of class counsel, among other things says class counsel owes a primary duty of care or fiduciary responsibility to the class. They added Rule 23H on attorney fee awards, and the committee notes, which I had a hand in writing, emphasized that the real benefit for the class is an important measure. I think both of those things might suit the world that Marty would have us move towards. So where are we now? We are now reviewing some of these questions again. We being the advisory committee. A couple of years ago, we got up a little list of things that might deserve attention: settlement class certification, settlement review, merits review in connection with class certification, CPRE, which I think Marty might mention. So all of these things are on our docket, except what you'll hear about in your second panel this afternoon, arbitration. That's statutory. So let me conclude with my basic view that the courts are the place where the action is. The action is there because American lawyers and judges are so creative. The wind is blowing generally in a direction that is not that favorable for plaintiffs seeking class certification. They are bending in the breeze. And I think we have to take with a bit of caution some of the statements about how the world is going to end. For example, in terms of the fraud on the market theory, a leading defense lawyer said recently, quote, defense attorneys would prefer basic, that's the case that might be overruled, a known quantity to what Congress might enact. It's the plaintiff's side of the debate in this session that was reported in the press, the plaintiff's side that said if basic goes, that would, quote, completely gut securities litigation. I don't think anything is going to prevent further innovation by the remarkably innovative graduates of this school and many other schools. I wanted to close by saying happy 100th birthday, a little belatedly, to Randolph Thrower. It sounds like he was the kind of lawyer that's still turning out and those lawyers find a way to get the job done. Thank you.
I appreciate Rick telling you what I was going to say. I would have preferred if he had said spoiler alert at the outset. I view my role here differently from my two prior colleagues, because instead of telling you about what the Roberts Court is doing and thinking, I'm going to be telling you what the Roberts Court should be thinking and doing. I tell my students that the greatest advantage of being a law professor is that you get to overrule the Supreme Court every day of the week. The disadvantage is that no one ever listens to you. But I'm going to forge ahead. Also, unlike my colleagues, I'm going to sort of take a step back, pan out. I'm going to head for the forest rather than the trees, because I think that can tell us a great deal about the trees. I want to talk about the deep structure of the class action, and the modern class action in particular, which means post-1966. Let me start with what should be basic propositions, but seem not to be recognized by everyone. Contrary to what many leading procedural scholars, judges, and heaven knows plaintiffs' lawyers tell you, Rule 23 is not a roaming device for doing justice. Rule 23 is just that, a federal rule of civil procedure. It comes right after Rule 22, interpleader, and right before Rule 24, intervention. It is a complex aggregation device that presupposes it is enforcing underlying substantive law untied to Rule 23. Rule 23 does not itself create substantive law. And that's a view I've held for a while. But up until now, I have always equated Rule 23 with the other complex aggregation devices. And in thinking about preparing for this symposium, it's occurred to me the modern class action is a different procedural animal from any of the other devices. The modern class action, meaning post-66 again, is a representative form of litigation never before seen in history. We have had things called class actions. If you go back to Justice Story's equity rules, you had representative litigation. But what we never had was representative litigation where there was no pre-litigation substantive intertwining or intersection between the representative party and those being represented, the absent class members. And I really wonder if those geniuses, and they were geniuses of a kind never seen before in procedure, who drafted the 1966 rule, really understood what it is they were doing, how they were changing the nature of underlying litigation. We no longer have aggregation in the sense of one-on-one attorney-client, attorney-client, attorney-client. The relationship between the representative litigant, between, more importantly, the class attorneys and the absent class members is qualitatively different from the traditional lawyer-client relationship. Think of it this way. Unlike the traditional lawyer-client relationship, class attorneys will never have met most of their clients. To the attorneys, they are basically faceless. Unlike the traditional attorney-client relationship, the class attorneys will, as a general matter, be making considerably more money than any one of their clients. I cannot think of any one-on-one attorney-client relationship where that is true. Unlike the traditional attorney-client relationship, there is the potential for a conflict of interests between the clients and the attorneys. I think of the Walmart case where you had the plaintiff's attorneys fighting like the dickens to have the class classified as a B2 class, the result of which was their clients weren't going to be able to get notice and wouldn't have the option to opt out, as they would under a B3 class. But the B2 class made life much simpler for the attorneys, even though it had a negative impact on the interests of the individual class members. In many ways, the modern class action is similar to the new wave of third-party financing of litigation, where individuals finance individual litigation in the hope that they will be victorious and make money from it. And the biggest problem I've seen with third-party financing is that you have individuals who have some influence or control in the process who have no connection with or obligation to the actual peoples whose interests are involved, the claimants. The difference in third-party financing is you have an attorney who is a buffer between the financiers and the claimants. The attorney makes most of the decisions. The attorney has the one-on-one bond with his or her client. In the modern class action, the financier is the attorney. The attorney makes an investment in the class proceeding and often has competing interests from the absent class members. So how do we characterize the modern class action if it's not really a classic aggregation device? I've decided to categorize it as a form of guardianship, that the attorneys are representing wards who cannot adequately represent themselves. And this is not necessarily a bad thing. To have a guardian representing you avoids significant transaction costs in enforcing your rights when the individual's rights may be too small to justify enforcement, when the individual may not be in a position or sophisticated enough to find out they have the rights. The class attorneys acting as guardians perform that function. But it is important to understand how these guardians operate. This is not your normal altruistic guardian. This is not your normal governmental guardian. This is a capitalistic guardian. In many ways, the modern class action is a form of capitalistic socialism. That conceitedly is an oxymoron, much like the phrase Northwestern NCAA tournament bid. But that doesn't mean it's invalid. It is socialism in that it is concerned with redistribution of wealth. It is capitalistic because it is being done for profit more than fun. And again, there's nothing wrong with that, unless there are externalities or perverse economic incentives that separate the interests of the capitalistic representatives from their claimants. So if we can assure that the capitalistic interests of those who are acting as guardians for the absent class members actually overlap, are coterminous with the interests of the class members, then everything should work effectively. There are many, however, externalities or perverse incentives under the current process, and they need to be corrected. There are situations where the attorneys stand to gain financially even when their claimants, their wards, don't stand to gain financially, and we need to change that. The first thing we need to do is to strike down what I've called the faux class action. To understand the faux class action, imagine a photographer on the street corner in Washington with a life-size cutout of a smiling Barack Obama, and you can have your photo taken with your arm around the smiling Barack Obama, and when you take the picture home, it looks like you were standing next to Barack Obama, but you weren't. You were standing next to a cardboard cutout of Barack Obama. All too many class actions are like that. It looks like there's a class, but in reality, it's a cardboard cutout of a class. The class is basically comatose. The class has no idea that this lawsuit is going on. If they've received notice, they're usually confused about it. Once my father-in-law called me totally panicked. He'd gotten something in the mail. He thought he was being sued, and I explained to him that No, actually, he was just a member of a class, and it's the only time he ever thought I was worth anything. These faux class actions are situations where, as a practical matter, virtually none of the class is ever compensated. The money goes to Mother Teresa. The money goes to a charity, and this is the practice of see, pray. Now, I should have emphasized at the outset, I have heard many people I respect pronounce it cypre. That is technically not accurate. It comes from a French phrase that begins with the words...
But it's a legal phrase in America, and it's cypre here.
Yeah, well, one of the three things you don't want to get in an argument in a bar about are religion, politics, and how this phrase is pronounced. If my students mispronounce it on their finals, I take off. And I will concede that the award for the best pitcher in baseball is not the Cy Young Award. So if you want to call it cypre, knock yourselves out. But what it basically is camouflage for a faux class action. It is giving the money to charity, to the phrase actually comes from a trust doctrine that goes back to the time of Justinian, where a settler's trust can't be effectively or legally enforced. It goes to the second best. And somehow in the 1970s, it got turned into a class action device where there is no second best. Either you win or you lose. I had a research assistant trace the source of the Nile. At what point did this go from being a perfectly legitimate trust doctrine to a very illegitimate class action doctrine? And she found a 1972 comment in the University of Chicago Law Review, which I found was written by a partner at the law firm I'm connected with, Sidley Austin. And he confided to me recently that if he had known what this was going to lead to, he never would have written it. But basically, the cypre doctrine authorizes a cover for an inability to compensate class members. The bulk of the money goes to some interest that is considered in the team photo, something a charity that is sort of kind of like the injuries to the absent claimants. In the recent Facebook case, absolutely no money went to claimants. It all went to a cypre award. And of course, the attorney's fees are measured directly or indirectly, depending on which device is used, by reference to some sort of measure of the full award. Not the award actually obtained by actual claimants, but just the money given by the defendant to buy peace. This doctrine has to stop. If the claimants cannot be rewarded, there should be no class action. This is not a roaming device for doing justice. It is a device for enforcing the rights of litigants whose substantive rights have been violated, with the goal of compensating those litigants. And this comes to my final recommendation. Actually, I have several other recommendations, but the final one I'll mention today, which is an amendment to Rule 23. I have an old friend in the audience who is on the Rule 23 subcommittee, and my co-author here is heavily involved in it, so I will just tell them, why don't you just add to the certification requirements an additional prerequisite, a finding that a successful prosecution of this class action will lead to the provision of meaningful relief to the absent class members. If those seeking certification cannot make some kind of showing that there is some reason to expect and hope that the actual injured parties, what a radical idea, will get compensated, that case has no business in federal court as a class action. And by recognizing this capitalistic guardianship model as really the DNA of the modern class action and attempting to remove the perverse economic incentives and the externalities that might pathologically impact the functioning of the free market system here, I think we could actually make an effective class action device. Thank you very much.
Well, I'm going to provide a bit of a report from the trenches. So as a practitioner and someone who handles class actions and deals with them virtually every day, I have to report that they are alive and well, and they're being filed at a higher rate than ever. In fact, according to one report that I read, the number of class action lawsuits rose 16% between 2011 and 2012. 2011 is when the Supreme Court decided the Dukes case. So plaintiffs' lawyers have not been deterred from filing them. And I think that that's all the more reason why the points that Professor Redish made, I think in particular, are so important. And we have to take a step back and think, what is the purpose of the class action device? What are we trying to accomplish? And what is the proper role? And I think that's what the Supreme Court was trying to do in Dukes and Comcast, is to reset the balance. And so I would submit that the court did not slam the door on class actions, but it attempted to reset the balance and to help us regain perspective of what the point of class actions is. And I think there are three principles that I have that I think we should take these decisions, to represent. And they are, first of all, reaffirming that class actions are the, and I'll quote, exception to the usual rule that litigation is conducted by and on behalf of the individual named parties only. And that to justify a departure from that rule, the class representatives must possess the same interest and suffer the same injury as the class members. And that seems like a pretty obvious point, but it was completely lost for decades, I would say. And what the Supreme Court said in Dukes is that we need to take a step back and recognize that that this is the exception, and normally the thousands, or in that case, 1.5 million absent class members would be entitled to their own day in court. So if we're going to preclude them from having that, we better have a very good reason, and we better be very careful, because their rights are at stake, and the rights of defendants. And the second principle is that this, and this is from American Express versus Italian Colors. I think this is a very, very important statement. Where the court said that the stringent requirements of Rule 23 in practice exclude most claims. Again, this is not the rule, this is the exception. And why is that? There's a very good reason for this, because we're talking about non-party preclusion. And as Justice Ginsburg said for the court in Taylor versus Sturgill, because of that, we require, quote, crisp rules with sharp corners. Another very important principle. And for those who have criticized the Roberts Court and the usual 5-4 majority, it's also very important to recognize that Dukes was in part unanimous. The Taylor versus Sturgill line I just read, that was Justice Ginsburg. Justice Ginsburg also authored Amchem, another extremely important decision. So this is not just a 5-4 majority, but I think it's the entire court that's very concerned about the tail wagging the dog when it comes to class actions. And why is that? What we were seeing before Dukes is that courts, district courts, and even appellate courts were taking a wait-and-see approach. They were not getting into the merits at class certification. They were punting. They were assuming that, and it was true, that most of these cases would settle before trial, so no one was concerned very much about how the case would ever be tried. And again, that's the wrong way to be looking at this. And why is that? Because you can't use a procedural device to alter the substantive law. You have to start with the claims, the elements of the claims, and the defenses, and think about how the case will be tried. And if you can't do that on a class-wide basis, then this isn't a proper class action. And so in federal court, Rule 23 should be interpreted strictly, and we have to keep in mind the Rules Enabling Act, which says that the procedure can't alter the substantive law. And we also are concerned about due process. You're binding absent class members who never get their day in court. They will be precluded from ever bringing their own claims in the future. And in the Dukes case, we were talking about claims under Title VII that were up to $350,000 in compensatory damages. I mean, these are not negative value claims. These were claims where if a plaintiff had an actual suit, they could bring that suit, get attorney's fees. There was every incentive to do that. So again, the kind of inventive use of Rule B2 there just to get a class certified, a sweeping nationwide class that was bigger than the entire United States Armed Forces combined. And I did the math and added it up. And I remember being astonished because the proposed class was 1.5 million absent class members, which was larger than the Army, Navy, Air Force, Marines, and Coast Guard combined. And it doesn't seem reasonable to think that every single one of those 1.5 million women had suffered exactly the same injury. And so it's not altogether surprising that the Supreme Court rejected certification there unanimously. And the unanimous part of the court's opinion rejected the use of trial by formula and shortcuts, extrapolation, et cetera, to get around the manageability problems of trying the case as a class action. And that's very important. And one of the reasons why it matters so much is I believe that Rule 23, and in particular the court's ruling on trial by formula, is grounded in due process. And that means that it should apply in state court as well. So if you really take the Supreme Court's decision and go back to first principles and think about where Rule 23 comes from and the concerns of due process and binding absent class members, I think that those principles should reign in state court class actions as well. And that's, I believe, the next frontier. We are currently seeing an increase in statewide class actions in places like California in wage and hour suits, for example. And the California Supreme Court has granted review in a very important case, Duran versus U.S. Bank, which considers precisely this issue, which is, can you use shortcuts like extrapolation? And can you try the claims of a handful of people, of plaintiffs, and say, we're going to get an average number of damages, and then we're going to award that to everyone in the class. And in practice, that means that some class members who were not injured at all will receive a windfall, and others who, and they would have had no claim if they'd brought it on their own, but the defendant had no chance to defend itself against that person's claim because of the class action procedure. So the defendant goes in with its hands tied behind its back. The absent class members get a windfall, but then some class members who may have actually suffered more damages will just get the average. That violates their right to due process. So I think Professor Redish's point about needing to look out for the absent class members is very important, and I think Justice Ginsburg and this court is concerned about that as well. It's not just about the defendant's rights, but it's interesting because in many cases, the defendant's interests will be aligned with those of the absent class members. So there's the plaintiffs, the named plaintiffs' lawyers are not going to be making arguments about the Rules Enabling Act and altering the rights of the absent class members. It's often the defendants who end up making those arguments. So I find that particularly interesting. And then I'll just, I know that we don't have that much time, but I will just say that we've heard some talk about the Sixth and Seventh Circuit cases in the washing machine cases where Judge Posner had a decision in Butler versus Sears. Those are, there are cert petitions currently pending in the Supreme Court, and I believe the next conference is on February 10th, so that's coming up. And it will be very interesting to see if the court grants those cases. But there's a disconnect, I believe, between the kind of theory of efficiency between class actions and this push toward aggregation at all costs versus the reality. And in the court in one of those cases remarked that the defendants should welcome class certification because if the defect did not affect a majority of class members, then the defendant would be exonerated because in a trial on the merits, the average, it would turn out that it was more likely than not that people were not damaged and therefore there's no recovery. That can't be right. It's, again, more trial by formula and sort of averaging across a class, and it's a fake class action. It's just sort of coming up with this hypothetical situation, trying it, and the absent class members don't matter, and whether they have a claim or not, they get some sort of average recovery. So I would just say also a last point that as we're thinking about creative ways to get around the barriers that are perceived to have been erected by the court in Dukes and Comcast, we heard from Professor Miller about the use of C4, which nobody really knows what it means. I think there's a way to determine what it means, and there's a way to determine what any whether it's permissible to engage in any sort of creative interpretation of Rule 23 or class action procedures to, again, get around what we think are challenges. And I would go back to the court's decision in Ortiz versus Fiberboard. And there the court said that any interpretation has to be focused on the text of Rule 23, the Rules Enabling Act, the Constitution and due process, and historical practice. And that's because the rights of so many people who are not present are at stake. And so I will just say that as we see the development of class actions in state court, it will be interesting to see whether state courts will will adopt the reasoning in Dukes and recognize the due process considerations, but there are a couple cases, and the Duran is one of them, that were actually tried to the merits, and so would be a very, I think, appropriate vehicle to end up in the United States Supreme Court. And the court could be confronted in that case, and there's another case in Pennsylvania that would be in the same posture, where the court could address whether due process imposes restrictions on state courts, just as Rule 23 and the Rules Enabling Act impose restrictions on federal courts.
So before we get to questions from the audience, I wanted to afford the panelists an opportunity to respond to each other, including on the pronunciation of particular phrases, or as they see fit, and also to ask questions of the other panelists based on their presentation.
I just would like to ask one quick point. If there are more Walmart workers than there are members of the armed forces, and I know they sell guns at Walmart, what is to prevent them from taking over the country? That was a rhetorical question.
Okay, good. I have no answer.
Can I offer a footnote, not a rhetorical question, which reminds me of something I said about Marty's very penetrating analysis of a lot of issues. What I understood to be the due process argument being made here, perhaps applicable to state courts, actually sounds a whole lot like what's a fierce contemporary debate in Europe, where group litigation has run up against the question opt-in or opt-out. Our rule is opt-out maybe. That is, in a Rule 23b3 class action, class members are supposed to get a chance to opt out, not the other kind. And in at least Germany, the notion that personal autonomy requires opt-in is critically important. So that sounds like the due process argument that we might be hearing. Even some German scholars who endorse that general attitude recognize that in a 10-euro claim situation, where the average claim is 10 euros or the alleged bilking is 10 euros per person, their opt-out won't work. And so, again, as I think I suggested, the ocean liner of American procedure and the ocean liner of the rest of the world may be converging a little bit, but there's still a big gulf between.
Let me just ask Marty this question about CPRE. I say CPRE. Sorry, Rick. But but it is, I do think it has gone too far in many, many cases. So I'm not in disagreement with, in general, what's happening out, your perception of what's happening out there in terms of how it's being used. But it seems to me, particularly in the state arena, as opposed to the federal class action arena, insofar as you see it, or state courts are in a position to interpret that their state consumer statute, or their, that there is a statutory policy that this really is a private attorneys general, that this really is something that, okay, you're never going to have people who eat potato chips who are going to be able to come in and prove claims that they paid 2 cents too much per bag because of price fixing, or state price fixing. And so isn't there a role, even in that kind of, there is no client, I know you'd like to have clients, but isn't there a role sometimes, if you can say under state law, in certain kinds of cases, for that kind of group litigation?
That's a really good question. If the underlying substantive law creates a kind of parens patriae, collectivist damage action, almost like a civil penalty, quasi-damage civil penalty thing, I have no problem with it. The problem in the federal situation is the underlying substantive law creates individual damage remedies. and the rule provides for the, through representative litigation, implementation of those damage remedies. And the CPRE remedy turns it into the equivalent of a civil fine. It's a kind of alchemy to change the underlying DNA of the substantive law. I should note that as a doctrinal matter, there's quite a bit of buyer's remorse going on around CPRE. Courts of appeals, while they haven't gone to the extent that I've argued, suggesting that there are serious constitutional problems here, a whole bunch of lower federal courts have backed off and disapproved a lot of CPRE remedies. And Chief Justice Roberts, in the recent denial of certiorari in the Facebook case, issued a separate opinion where the only thing he cited was my article, so that I owe him one. But he said, look, we're denying cert here, but this is a real problem. We need a better case. He openly invited a better case. So in many ways, CPRE may be dead man walking at this point.
Just as a footnote to what was just said, California has, as often, a strange twist on this. Section 384 of our Code of Civil Procedure says more or less that state courts are commanded not to permit the reversion of settlement funds in a class action to the defendant, but instead to put them to the next best use, which is a great deal like, I guess I'll give in to the tidal wave of pronunciation I'm dealing with, CPRE as a command from the legislature. Perhaps out there somewhere is another Shady Grove type case. If someone argues in a California federal court that this California law diversity class action must adhere to Section 384, I'm not aware of that having happened, but it might be out there in our future.
Good exam question for Civ Pro teachers.
Particularly in California.
Is this open book, or? The one way to avoid the problem, though, is to, at the outset, to front load and have the prerequisite that there must be a finding that there will be meaning relief to the victims.
Been there, done that, sort of. In 1996, a package of proposed changes to Rule 23b-3 was published for public comment. One of them was a change that came to be labeled the just ain't worth it change, which more or less said what Marty is endorsing. Now, the conclusion then was, in light of the commentary the committee received, just ain't worth it, just ain't worth it. And it was not pursued further. At that time, among other pleasantries the advisory committee received. There was a letter or comment from 127 what were described as law school civil procedure professors denouncing the entire package, but that as one of the things that was perhaps most worthy of denunciation. Surely that possibility exists, but it must be examined against the background of what has happened before.
Well, I wonder if you couldn't achieve the same goal by really having more teeth in the adequacy requirement of Rule 23. I mean, I haven't seen many decisions denying class certification based on adequacy of class counsel, but where class counsel really throws the absent class members under the bus in order to get a class certified and will do anything just to get attorney's fees, then I would think that that should make them inadequate as class counsel.
Well, we do now have Rule 23G. Rule 23G requires the court to appoint class counsel if there are competing, well, first the court must determine that class counsel is adequate, and surely at some point one might conclude class counsel is not adequate. That has happened. Secondly, the rule says that if there are competing applications, lawyers don't like competing with each other. Antitrust laws presumably apply to lawyers too. If there are competing applications, the court must appoint the lawyer most adequate, even if there are multiple adequate applicants. That's a challenge for judges. Probably the wind could blow in that direction at some time. The rules are already pointed that way. I don't know that they could point that way more effectively.
Can I just add one thing? It is very comforting to know that the Rules Advisory Committee makes its decisions on the basis of a vote of civil procedure professors with technological
I didn't say
advances. It sort of sounded like that.
In a law school, one notes these things. We received recently another public comment on our current package signed by 110 law professors, and I did not say we will do what they said. I just used that as a measure of
You can have them
pressure.
vote through their computers now. I just thought I'd let you know.
We aren't having voting.
Okay, well, I think we have about 15 minutes remaining in the session. If there are questions from the audience, I think we have microphones set up on both aisles, and if people just want to come up to the microphones and ask questions, I think we have somebody, please.
Okay. Well, thank you today. The social planner inside me is sitting here thinking, well, there's all these problems. There's problems if we go too far in this direction, there's problems if we go too far in this direction, and on the one hand, we have these negative value claims, and if those can't be meaningfully vindicated, that seems to be a problem. On the other hand, it seems like what we have right now are a lot of perverse incentives and that kind of thing. And we've talked about these C-prey claims, but then often with the C-prey claims, the actual people who've been harmed don't actually get vindicated. So if you're the social planner, do we need a complete overhaul of the current procedure that's used in order to bring the valid interests on both sides together and to get rid of the problems? Or is it just a lot of little tweaks that need to be made? I guess, do you have any ideas?
Let me respond to that, because it's a really good question. If Congress's goal in creating these damage remedies is also to have them perform a private attorney general function of policing, and the individual damage claims are so small that not only will they not bring individual suit, but it's not really feasible to compensate them through collective suit, then Congress needs to go back to the drawing board and maybe adopting some sort of federal alternative to what apparently California has. But Rule 23 is too small a tail to wag that dog. Rule 23 can't implement that kind of major sea change in the nature of underlying substantive social policy.
Let me just add to that in a slightly different take. Abstractly, I would agree with Marty, except that, again, I said at the end of my thing, I'm a pragmatist. Congress is not about to go back and take these statutes and say, oh, yes, you can use CPRE. I mean, this Congress is not likely to do anything, but they certainly aren't likely to do that. And so it's not realistic. I mean, abstractly, yes, that would be the way to handle it. Have the legislature be clear about when they want things like that to use or not. But it's just not going to happen. And so I think that that essentially you're not talking about totally rewriting the rule if you could. The rule can't address many of these things, because that's not going to happen either. So I do think, in a sense, what Theane said earlier, it's an adjustment process. I mean, the courts need to be aware of the ramifications of what they're doing and not just knee-jerk one way or the other. They need to think and ask themselves. They have the discretion to look at all these factors right now, even in looking at certification. They need to sort of be aware of these larger things looming out there and think about adjusting appropriately case by case in the common law tradition. And ultimately, maybe the Federal Judicial Center can do some better training, so other judges who aren't familiar would find out what's happening out there, have better ideas out there. But I think it's just a process of adjustment back and forth.
I don't think pragmatism can get you as far as you need to. Basically, as it's currently construed, Rule 23 is lawless in multiple ways. It violates the act that it owes its existence to, the Rules Enabling Act. It violates basic principles of due process. And to the extent it tries to achieve the functions you're talking about, it blatantly violates democratically or authorized separation of powers. And to respond to all of those violations of our basic structure with some notion of ideologically driven pragmatism, I don't consider an adequate response, even if, as happens to be the case, I may well agree ideologically with the concerns that you're invoking here.
It's also a question of institutional competence. Do we, as a society and in our democracy, do we want courts to be the branch and the institutions that are regulating society, whether it's the automotive industry, the pharmaceutical industry? Do we want courts to be redistributing wealth? Do we want them to be, addressing all of these issues, or should they be handled by an agency, an administrative body that can really study what the impact is of a certain manufacturing process or a certain drug or what have you? But is it really for courts to be looking at social problems and coming up with solutions and then just, doling out minimal recovery to absent people who had no idea that this was even happening? I think that's a very kind of fundamental question, and perhaps this Congress is not going to do anything to change Rule 23 right now, but I think what we've seen is a bit of a backlash because the courts are saying, this is not the right forum, to be adjudicating this type of grievance, and where actually many people don't have individualized grievances, and they would not have access to courts. They would have no standing under Article 3 to even get in the door, but they're somehow here as part of an amorphous body because we think there's a social problem and someone brought a class action looking to capitalize on it for the social good. Capitalistic socialism. I really like that. Thank you.
Can I offer a broader perspective for this issue of whether courts should do things? Since the Erie decision, there's been a difference between what federal courts are authorized to do and what state courts are authorized to do. The whole idea of the common law system is that to some extent courts can do those sorts of things. Some of you may in your torts classes have heard of something called products liability. You might ask, which legislature adopted that? I think the answer you would find is that courts developed that. Courts developed that for, you could say, social purposes. Now, the Erie decision, in effect, and Marty is an expert, I'm not, the Erie decision, in effect, said federal courts don't have that warrant from Congress. That doesn't mean state courts can't do that. which might be a problem with CAFA moving cases to federal court. But it's a very interesting academic question how far legitimacy of judicial action goes. At least mid-20th century, it went pretty far.
Question is based on Professor Marcus's comments on group litigation in other countries. I'm curious to know if there's any lessons that American judges and lawyers can learn, whether positive or negative, from the way that group litigation proceeds in other countries.
Dandy question, thank you. I think there's a lot of lessons to be learned for American lawyers in general from knowing more about what the rest of the world does and thinks, and particularly what it thinks of us. I don't mean that we have to do exactly as France does, but it is interesting to me that if you looked at what I will call the laundry list of U.S. Chamber of Commerce wish lists for civil litigation here, it's that it'd be a whole lot more like France. The question whether we should move in that direction depends upon appreciating that litigation in this country, in many instances, serves a different purpose than litigation, civil litigation in other countries, and that's a big topic we don't have time for. I think in terms, for example, of something that Mary Kay and I attended a few weeks ago about group litigation developments in Europe, it's interesting to appreciate that the word we heard was what I called the German attitude towards individual autonomy for the 10-euro claim may be losing momentum within the larger European sphere. So maybe to some extent they are learning from us. But I surely think in this way and in other ways we could learn from them. I think if you look at group litigation outside this country, you will often find that it recognizes groups that have what you might call a pre-existing social compact with one another, or which I think Marty was alluding to, which American classes don't often have, and recognizes those pre-existing groups as authorized to litigate, or sometimes says only what we might call a coattails class action, only when public authorities have established, say, the illegality of conduct, can the groups or private lawyers ride the coattails forward for damage recoveries for those who were harmed, which is sort of a mix between parens patriae and some sort of class proceeding. So yes, more generally, learning about the rest of the world is a good thing, and particularly on this score, as on many, it is eye-opening to see what, I won't call it revulsion, but what reaction the rest of the world, which is civilized too, has to the way we do things.
I'd like to ask you to address a little bit Professor Redish's father and people in his, pardon me?
My actual father did think I was worth something, but father-in-law didn't.
Only once for his father-in-law, more often for his father.
Getting all these people that are unrepresented getting a notice. They're all just potential class members, right? They have to opt in to an extent in some of these cases. So he wouldn't have to prove anything.
No. They don't have to opt in.
Okay.
If it's like the Book of the Month Club. They'll send it to you unless you send it back.
Problem is you don't get a book.
Yeah, right. And actually, the FTC ruled that an unfair trade practice, but it's what we do in Rule 23. It's you are the proud member of a class unless you write in to tell us that you're not.
Don't want to be.
Right.
But there are cases where you get a notice and you've got to prove, for example, that you own something.
To actually recover.
Yes.
Yeah, that's part of the faux class action problem. For a $30 claim, people aren't going to look for receipts from 20 years ago or 10 years ago about some CDs they bought or something that were price fixed.
Can I just add to what Marty just said? The relationship between real value and claims process is something I think judges have learned to focus upon. The attorney fee award may be premised on the $10 million settlement here, but if the claims process means that only 5 people actually get money and says that the defendant gets back whatever is unclaimed, that's a serious concern with a settlement where you might have some tension between the lawyer's interest and the class member's interest. That's an education task for judges to know what to look for. One thing they might look for is whether there's a reversion provision. And if the defendant doesn't stand to gain because not very many people make claims, maybe there's less reason to make the claiming procedure really elaborate. But at some point, you really would like to be delivering money to people who really suffered a harm. The California Attorney General once brought a suit about overpricing of jeans in California, and the court eventually decided something like, if you are claiming to buy more than 10 pair of jeans a year, you have to show some proof that you actually did buy them. So there's a variety of things to keep your eye on.
So for those with the small claims that never even know they have them, you make unintended philanthropists through the blank prey doctrine.
Well, I guess the philanthropist that's being left out is the defendant that was overcharging all these people, and that didn't sound philanthropic to me either.
I love the phrase unintended philanthropist. Can I use it? I appreciate that.
Well, I think we are out of time, so please join me in thanking the panel for a wonderful discussion.